What's going on, everybody? Hey, look, I'm gonna jump on here real quick because I got some great news. I'm taking a quick minute out of my lunch right now to post this. Now, for people who live in New Jersey, it doesn't initially help us, but it does open the door. The floodgates are about to open completely, and it's definitely case law that we can cite. Now, if everybody's not familiar with Young versus the state of Hawaii, it's a Ninth Circuit carry case, another one. But this was this was in Hawaii. The other one was in California. Still the same circuit, but this one was from Hawaii because Hawaii issued 0 carry permits. That's correct. 0. None. Even the state of New Jersey, who only has roughly about 400 to 1,300 carry permits, Hawaii issued none. So there was a case brought by George Young. He wanted to open carry because the Peruta case that was from California stated that concealed carry fell outside of the scope of the Second Amendment, but didn't say anything about open carry. So basically, I think it was in February the case was heard, the oral arguments were heard. 12-17808, Young versus the state of Hawaii. The ruling or the opinion was issued today. In that ruling, I did not read all 76 pages, but the first few lines, first paragraph, pretty much sums it all up. And it states that though they recognize that concealed carry falls outside of the scope, and they cite the Peruta case, stating that that's what the en banc ruling stated. Because remember, I don't want to jump off topic, but the Peruta case, he won originally. Then they appealed, and the en banc court overruled it. So the en banc, they quote the en banc court saying that concealed carry falls outside the scope of the Second Amendment. So in this opinion, they said, per Peruta, the Second Amendment doesn't really cover concealed carry. However, the court, on a 2-1 decision, three judge panel, ruled that open carry, that the Second Amendment protects an individual's right to open carry for self-defense in public. No in the home case. Pretty much straightforward with that sentence. That the Second Amendment protects an individual's right to open carry for self-defense in public. So I just wanted to jump on here and say it might not be over. Hawaii could appeal it and to an en banc court, and Ninth Circuit en banc court is full of liberals who hate the Second Amendment. So I don't know where that goes. However, with the chances of having another Supreme Court justice on our side, they may take the same route that D.C. did. When D.C. lost the Wren case, Wren versus D.C., when they lost, other states like New Jersey, New York, California, and Maryland reached out to D.C. and said, you might not want to appeal this, because if it goes to the Supreme Court and you lose, it's going to affect all of us. So they chose not to. After the 45-day window, whatever they had to appeal, it opened the door now for people, residents of DC, to get their carry permit without needing the good cause, or what we call in New Jersey, justifiable need. So if they do the same thing out in Hawaii, and they don't appeal it because they don't want to lose, that's a win. And then really then we can start using that case, we can start citing that case in our cases here, and then since there's a split in the circuit, that opens the door for our cases to actually be heard in the Supreme Court. Because that's the whole point. When you have multiple circuits disagreeing on the same topic, then the Supreme Court has to step in. That's their job. Step in and say who's right and who's wrong. With the chances of us finally getting a good 5-4, because before he announced his retirement, he was at swing vote. We really didn't know which way he was going to go. But now we can if he gets in there, he gets confirmed, which I think he will. That's a solid 5-4. You pretty much not really have to guess too much how it go. I'd like to get Ginsburg off the Supreme Court. Hopefully that happens soon. But anyway, my original point is, way to go, Hawaii. George Young and people who helped him out, his lawyers, the NRA, the ones who pitched in to get that case where it is. It's a big deal. We don't know exactly where it's going to go until Hawaii runs out of time. They're going to have a limited amount of time. It could be 10 days to file an appeal en banc. I don't know what the date. It could be 10 days. It could be 45. I'm not sure. But when that's done, either if they did en banc, we have to wait, and then we can appeal it to the Supreme Court, or George Young can, or they don't appeal it, and then it becomes precedent, and then other states, other circuits, we can cite it. It doesn't mean that them other circuits have to follow it, but it's persuasive to say, hey, even the Ninth Circuit recognizes we have some form of right to protect ourselves outside the home. So, until next time, peace.